Before we get into this important discussion, I need to be very clear about one thing, because there is a tremendous amount of dangerous misinformation circulating right now across social media platforms, messaging apps, and community networks where people share information without verifying its accuracy or understanding its implications. There is no magic phrase that guarantees you will avoid arrest during an immigration enforcement encounter. Anyone telling you otherwise is selling a fantasy, and that fantasy can put real people in real danger when they need accurate information the most. There is no secret sentence you can say that suddenly makes enforcement disappear. There is no clever wording that overrides everything else happening in that moment. There is no special incantation that transforms a difficult situation into a simple one. What is real and what actually matters is something different and more nuanced than the viral content suggests. The words you choose in the first few seconds of an encounter with ICE can protect you in meaningful ways. They can limit what you accidentally give away through casual conversation that feels harmless but carries serious consequences. And they can preserve defenses that a lawyer can use later when fighting for your case in immigration court or challenging the circumstances of your detention. That distinction between magic phrases and strategic silence is critical for everyone to understand, especially now in the current enforcement environment. And it matters more than it has in years, because in late January 2026, multiple major reports from credible news organizations and legal advocacy groups described a significant enforcement shift happening across the country. There are growing legal challenges around ICE officers relying on administrative warrants rather than warrants signed by a judge, particularly in situations involving home entry where constitutional protections are strongest. There are lawsuits underway in federal courts challenging these practices. There are public memos being scrutinized by legal experts and journalists, and there is national coverage highlighting how these enforcement practices are being tested and contested in courtrooms across America. This is not rumor or speculation or social media panic. This is being openly debated and actively litigated by attorneys, advocacy organizations, and government lawyers who are fighting over the boundaries of enforcement authority. So, with that context clearly on the table, what I am about to walk you through is not hype designed to get clicks and shares. It is not fear-based advice meant to frighten you into watching more content. And it is not social media theatrics that sound impressive but fall apart in real situations. This is a calm, lawful, practical explanation of the only 3 words I would ever tell someone to rely on in a stop, because they are simple enough to remember under stress. They are completely legal and within your constitutional rights, and they reduce the risk of you talking yourself into trouble that could have been avoided. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now, let us get into the video. Welcome to U.S. Immigration Info, your trusted source for accurate, practical, and lawful immigration information that helps you understand your rights and navigate difficult situations. We believe that immigrants deserve honest guidance based on legal principles rather than viral content that sounds empowering but can actually cause harm. Today, we are discussing one of the most important topics we have ever covered: what to say and what not to say during an encounter with immigration enforcement officers. Now, imagine the situation that many people fear, and that some have already experienced. You are walking to your car after a long day, or you are leaving work and thinking about what you need to pick up on the way home, or you are standing outside your building, maybe checking your phone, maybe thinking about something completely unrelated to immigration or enforcement or anything stressful. And then you hear it. A voice that is direct and unexpected. Hey, stop, we need to talk. And immediately, your body reacts before your mind has time to catch up and process what is happening. Your heart rate jumps. Your thoughts scatter in multiple directions. You feel pressure to respond, to explain yourself, to cooperate fully, to show that you are not a problem and that you have nothing to hide. Most people do not even realize they are doing it, but their brain starts filling the silence automatically. Words start coming out. Explanations start forming. Information starts flowing. And that instinct to fill silence with words is exactly where people get into serious trouble that can follow them for years. Because the real danger in an ICE stop is not always the stop itself. It is the moment you begin talking in ways you think are harmless and conversational, but that actually provide evidence and admissions that can be used against you. You start sharing details you have never thought of as risky because they are just facts about your life. Where you were born, how long you have been in the United States, whether you are waiting on paperwork or have an application pending, where you work and what you do there, who you live with and what their situations are, whether you have ever missed a hearing or had any problems with your case, whether you have documents with you right now, whether you are in the system and what your status is. That is not casual conversation between two people getting to know each other. That is evidence being gathered. That is admissions being recorded in officer notes and reports. That is a roadmap being built in real time that can be used to detain you, remove you, or undermine any legal defenses you might otherwise have available. Every piece of information you volunteer becomes part of a case file. Every detail you share removes options and flexibility that an attorney might need later. So, if you remember nothing else from this entire discussion, remember this one truth that legal advocates have emphasized for years. The safest thing you can do in an enforcement encounter is stop talking. Not rudely, not dramatically, not in a way that escalates the situation, but calmly, respectfully, and deliberately. Control your words because your words can either protect you or harm you, and you get to choose which it will be. And this is where the three words come in. They are simple. They are not dramatic. They are not clever or complicated or difficult to remember under stress. They are three words that assert a constitutional right while keeping you calm and safe. I remain silent. That is it. That is the phrase. Not a speech about your rights. Not an argument about what officers can or cannot do. Not a story explaining your situation. Not an explanation of why you are there or what you are doing. I remain silent. And I know some people react to that and think it sounds too small to matter, too quiet to make a difference, too passive to be effective. But in reality, those three words shift the entire dynamic of the encounter in your favor, because the moment you say, "I remain silent," you are not being rude or disrespectful. You are not resisting or obstructing or doing anything that creates additional problems. You are not escalating a tense situation into a dangerous one. And you are definitely not doing anything illegal, because remaining silent is your constitutional right. You are asserting a right that immigrant legal organizations, civil rights groups, constitutional lawyers, and advocacy organizations have emphasized for years as one of the most important protections available. You are choosing not to help build a case against yourself. You are preserving options and defenses that might save your case later. You are taking control of the one thing you can control in that moment, which is what comes out of your mouth. And in 2026, that choice carries even more weight than it has in the past, because enforcement tactics are moving quickly and the legal landscape is shifting. There is active legal debate around what authority officers are relying on, especially when it comes to administrative warrants and entry into private spaces like homes. Courts are issuing rulings. Lawsuits are proceeding. Advocacy organizations are documenting patterns and challenging practices. In a moment where information is fragmented and social media is full of bad advice from people who do not understand the law, one thing remains steady and reliable. You do not have to answer questions about your immigration status. That right exists. That right is yours, and you can exercise it by saying three simple words. Now let us be very clear about what this does and does not mean, because understanding the boundaries is essential for staying safe. This does not mean you run. Running makes situations dramatically worse and can result in additional charges or dangers that would not otherwise exist. It does not mean you lie. Lying to federal officers can create new legal problems and undermine any credibility you might need later. It does not mean you argue. Arguments escalate situations and rarely accomplish anything positive. It does not mean you try to outsmart anyone with clever legal arguments you heard online. That almost never works the way people imagine it will. What it means is simple. You stay where you are, you stay calm and controlled. You speak respectfully when you do speak. And you limit your words to the bare minimum necessary. Because what usually happens next is predictable. The questions keep coming, but they are framed to sound harmless and conversational, like the officer is just trying to understand the situation. What is your name? Where were you born? Do you have papers on you? Is this your car? Are you waiting on a green card? Are you here legally? How long have you been in the country? And this is the trap. The questions feel conversational, like small talk, like a normal interaction between two people. But the consequences are absolutely not conversational. Every answer narrows your options. Every detail removes flexibility your attorney might need later to challenge your detention or fight your case. Every piece of information becomes part of an official record that can be used against you in ways you cannot predict. So you repeat the same line if necessary, without anger and without explanation. I remain silent. You do not need to justify it. You do not need to explain why. You do not need to apologize for exercising your rights. You simply state your position and then stop talking. And then, when you can, you add one more important thing. Even though it is not part of the headline phrase, you ask for a lawyer. You can say, I want a lawyer, or I need my attorney, or I am requesting legal representation. Silence plus requesting counsel is how an encounter stops being an informal exchange where information flows freely and becomes something your legal rights fully attach to. When you invoke your right to silence and your right to counsel, you create a record that matters and you establish boundaries that have legal significance. Now, let us talk about something else that causes confusion and panic, because this is where people are getting seriously misled by content they see online. You will see viral clips telling people to argue with officers, to lecture them about constitutional law, to demand badge numbers aggressively and loudly, to shout legal phrases like they are in a courtroom drama on television. That content spreads because it feels empowering in the moment. It feels like fighting back. It feels like standing up for yourself. But real empowerment looks different than what makes for entertaining video content. Real empowerment looks like control. It looks like restraint. It looks like not saying things you cannot take back. It looks like protecting your future rather than winning an argument in the moment. Control sounds quiet. Control sounds calm. Control sounds like three simple words. I remain silent. Now, if officers come to your home or show up at your door or attempt to enter a private space, there is one concept you need to understand clearly because it is at the center of major legal debates happening right now. That concept is the difference between a judge-signed warrant and an administrative warrant. Many people do not realize that an ICE warrant can be an internal agency document, often identified by codes like I-200 or I-205. And that is not the same thing legally as a warrant signed by a judge with judicial authority. Administrative warrants do not automatically authorize entry into a private home without consent. This distinction is not theoretical or academic. It is at the center of current legal challenges, active lawsuits, and national reporting that is scrutinizing enforcement practices. And it is exactly why people are being told by legal advocates and know your rights organizations to calmly and lawfully decline to open their door simply because someone says they have a warrant. You can ask to see the warrant. You can ask if it is signed by a judge. You can ask for it to be shown through a window or slipped under the door so you can examine it without opening the door and potentially giving implied consent to entry. And if it is not signed by a judge, many know your rights resources say you may refuse consent to enter your private home. That does not mean officers will always leave, and you should never expect that asserting your rights will automatically end an encounter. And it absolutely does not mean you should physically block anyone or escalate the situation into a confrontation. You should never do that. Physical resistance creates dangers and legal problems that far outweigh any benefit. What it means is that you are creating a clear record of what happened. You did not consent. You stayed calm. You asserted your rights. You did not volunteer statements or information. You asked the right questions. That record matters enormously. That is what lawyers work with when defending clients. That is how defenses survive when cases go to court. That is how challenges succeed when practices are contested. Because here is another truth that people do not like to say out loud, but that everyone needs to understand. Even if you did nothing wrong, even if you have valid status, even if you have every right to be here, enforcement encounters can still cause tremendous chaos and disruption to your life and your family. Detention, even temporary detention, means missed work that can cost you your job. It means missed childcare that can traumatize your children. It means lost income that can threaten your housing. It means lost time that you can never get back. It means stress that ripples through families and communities in ways that last long after the encounter itself is over. So when people ask, what should I say during an encounter? The honest answer is not more words. It is fewer words. It is 3 words. I remain silent. Now think about body language, because that matters too in ways people do not always consider. Panic makes people reach suddenly. They grab for phones to record or call someone. They reach for wallets to produce identification. They dig for documents to prove their status. And even when intentions are completely harmless and cooperative, sudden movements can be misinterpreted in tense situations. Slow hands, calm posture, no rushing, no rummaging through pockets or bags without explanation. If identification is requested, the rules vary by situation and jurisdiction, but the core principle remains the same regardless. You do not volunteer additional information beyond what is specifically required. You do not answer immigration questions about your status, your history, or your case. You do not sign documents you do not fully understand, even if you are pressured to sign quickly. You repeat the line that protects you. I remain silent. People sometimes ask about new rights that have been created recently, and here is the honest version of that answer. Your basic rights are not new. The Constitution did not suddenly change this year. The Fifth Amendment, right against self-incrimination, and the right to remain silent have existed for a very long time. What is new is the level of confusion in immigrant communities about what rights exist and how to exercise them. What is new is the speed of enforcement changes and the expansion of operations into new areas. What is new is the legal fights happening right now around how authority is exercised and what limits apply. That context is what creates urgency for this information. That is why relying on viral slogans and dramatic content from social media is risky and potentially dangerous. You need something that works even when you are scared, something that works even when your English is not perfect and you are struggling to find words, something that works even when your kids are watching and you are trying to stay calm for them, something that works even when your hands are shaking and your mind is racing. 3 words that you can remember under any circumstances. I remain silent. Say them once. Say them again if needed. Then stop talking and wait. And here is one practical step you can take today to protect yourself and your family. Write down the phone number of an immigration attorney or legal aid organization and keep it somewhere physical that you can access, even if your phone is taken or unavailable. Not just stored in your phone, but written on paper in your wallet, memorized, or kept in a place where family members know to look. If you live with family, have a conversation and work through a plan together so everyone knows who to call if something happens, what to do, where important documents are kept, and how to respond. The goal of this preparation is not to win an argument with officers. The goal is to protect your future and your family's future. So ignore the fantasy advice you see online. Ignore the theatrics that get views but provide no real protection. Take something real with you, something that actually works. I remain silent. Those 3 words are not dramatic. They are not flashy. They will not go viral or get millions of views, but they reduce risk. They protect your options. They preserve your defenses. And right now, in this enforcement environment, that matters more than anything else. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. it is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info channel. Thank you for watching, and we will see you in the next video.